SPS Rahayu Mahzam.
Mr. Deputy Speaker, I thank the members who spoke in support of the bill. Let me now address the questions raised. Ms. Nadia Samdin asked whether the increased maximum fine for offences under Clause 5 is a useful and proportional deterrent. In particular, she cited cases involving individuals who are sleeping rough on state land or retired seniors who engage in unauthorised cultivation on state land. The enforcement framework set out in this bill covers all manner of encroachment offences, taking into account the different circumstances of trespass. The bill therefore sets out the maximum penalty since some forms of trespass can cause severe damage. Not all cases are eventually prosecuted in court. Furthermore, for those prosecuted, the penalties imposed by the court upon conviction will ultimately depend on the surrounding facts and circumstances. There is no minimum punishment for any of the offences in the bill. Also in practice, SLA generally does engage and will continue to engage those encroaching on state land. There would be opportunity to rectify the encroachments first, absent irreparable damage or danger due to the encroachment. In cases involving rough sleepers on state land, SLA works very closely with the Ministry of Social and Family Development, who will engage and provide support to these individuals. This could include referring them to suitable shelters or accommodation in the interest of their safety and well-being. With regard to the cases where enforcement action is taken, Mr. Louis Ng asked about the defences available to those prosecuted under the bill. This includes whether reliance on the due diligence of third parties would constitute a defence under Clause 7 of the bill. Mr. Yip Hon Wing also asked, in relation to the same clause, how individuals who encroach on state land can prove that they did not know and could not have reasonably been expected to know that the land concerned was state land. The scenarios under which a defence may be constituted are varied and will depend on the particular circumstances of the case. Nonetheless, the members' underlying concern appears to be situations where an individual does not know that they are encroaching on state land. Let me first draw members' attention to Clause 5 of the bill. The elements of the offence in this clause are engaging in the listed activities on state land without lawful authority and intentionally. Wholly accidental incursions would not be an offence. Also, as I mentioned earlier, SLA typically engages those encroaching on state land before taking enforcement action. On the specific example raised by the two members on private homeowners, the property owner should also take responsibility to ensure that there is no encroachment onto adjoining state land. This includes engaging a registered surveyor to carry out surveys to confirm if there are encroachments. If encroachments are found from the surveys, owners should check with SLA on whether the encroachment must be removed. SLA will also be embarking on public education efforts after the bill is passed to raise public awareness of the new bill and also address any misconceptions. Moving on to the process for abating encroachments. Mr. Louis Ng asked about the timeline to comply with or raise objections to the encroachment notice. Mr. Ng also asked if the authority will notify the result of the objection and provide time for individuals to comply with the notice before court proceedings are initiated. Let me first address the issue of the objection and compliance period. The removal of the fixed 28-day notice period is intended to provide SLA with greater flexibility to deal with encroachments more expeditiously if appropriate or necessary based on the circumstances of the case. To provide some context, this draws on SLA's experience with past encroachment cases, where members of the public had requested that SLA take action against the reported encroachments quickly. This is often because the encroachments might have posed disamenities and obstruction to the public. In addition, there might be cases where SLA needs to take action more quickly, for example, where there is ongoing harm being done to the state land. Nevertheless, SLA will strike a balance between giving individuals time to rectify their encroachments and stopping the harm done by these encroachments. In general, SLA will provide a reasonable timeframe for owners to comply with encroachment notices, taking into consideration the nature and scale of the encroachments. On whether the authority will notify potential offenders of the results of the objection, I would like to first clarify that once an objection is filed, Clause 16 of the bill allows the authority to refer the matter to the courts. The usual court processes after making a complaint to a magistrate under the Criminal Procedure Code will then apply. That said, generally, SLA will respond to the potential offender on SLA's position on the basis of his or her objection before filing a complaint to the court. Alternatively, the encroachment notice may be cancelled if there is merit in the case contained in the objection. Apart from the process for objection, the members concerned may also relate more broadly to whether there is sufficient notice given before matters are escalated to the point of legal action. As I've mentioned earlier, SLA typically engages those encroaching on state land before commencing any enforcement action. Most encroachment cases are resolved amicably. However, if there is a need to issue an encroachment notice, reasonable time will also be given to comply with the notice or to raise objections. This will be proportionate to the facts of each case. Mr. Yip Hon Wing asked about encroachments involving religious artifacts or buildings. Mr. Yip rightly pointed out that our laws should be applied consistently and fairly when it comes to encroachments, which could cause public obstruction or damage to state land. First and foremost, the setting up of any structures or leaving of any objects on state land without lawful authority would constitute an encroachment. That being said, similar to the approach for other types of encroachments, agencies typically engage the owners of any religious items placed on state land. Agencies will explain that these are unauthorized encroachments before taking enforcement action if needed. Where appropriate, SLA also works with the relevant religious organizations to ensure that the matter is handled sensitively and with respect. Ms. Nadia Samdin asked about safeguards to prevent trespassing under the pretext of a legitimate inspection under the bill. Authorized officers and enforcement officers must declare their office and produce their identification card when asked. The owner of the private land can demand to see their credentials, and when the officers seek entry for inspection or other purposes provided for in the bill. As stated in Clause 26, Subsection 3, if officers do not declare their office or produce their identification card when asked, it is not an offence for any person to refuse to comply with their orders. These provisions are directed at preventing illegal trespassing and scams, such as what Ms. Nadia Samdin had described. On the issue of public awareness and feedback, I thank Mr. Yip Hon Wing for his suggestion to leverage the use of technology in interfacing with the public on state land issues. Indeed, One Map is an example of our multi-agency effort to provide reliable, timely, and accurate location-based information and services to the public. While SLA does not have data specifically on how often the public uses information from One Map to provide feedback on state land, SLA does track the usage of One Map. SLA regularly promotes One Map through various social media channels. It has also broadened its efforts to raise awareness of the services on One Map to industry and members of the public. For example, SLA has signed collaborative memorandums of understanding with industry players such as real estate agencies, developers, and business chambers to promote the use of geospatial solutions. SLA will continue to review ways to raise awareness of One Map. Mr. Yip Hon Wing and Ms. Nadia Samdin also raised important considerations about coordination between agencies and adopting a resident-centric approach in resolving land-related issues. When the maintenance of land straddles the purview of multiple agencies, we will ensure that agencies coordinate our responses such that the issues relating to state land are resolved promptly. We recognize that it can sometimes be confusing for members of the public to identify the agency in charge. We have taken efforts to streamline our touchpoints with the public and to address their feedback effectively and efficiently. For instance, members of public can report or clarify state land issues using the One Service app, which is a one-stop platform where residents can provide feedback on municipal issues without having to figure out which government agency to contact. SLA will then follow up on any feedback or clarifications relating to state land issues. In addition, members of the public can also contact SLA's hotline to report any unauthorized use of state land. SLA will assist to direct feedback to the relevant agency if it is not within SLA's purview. Mr. Louis Ng, Ms. Nadia Samdin, and Mr. Yip Hon Wing ask about the process of forfeiture. Forfeiture of land is uncommon. We have encountered about 5 cases in the past 10 years. Mr. Deputy Speaker, sir, we recognize that the issue of forfeiture should not be taken lightly as it involves private owners' rights. To address Mr. Louis Ng and Mr. Yip Hon Wing's questions, in general, we do not actively identify abandoned land to pursue resumption. We typically take action when alerted to pieces of abandoned land that could pose a hazard to public safety or health. This could arise from public feedback on maintenance and safety issues, as pointed out by Ms. Nadia Samdin. The reduced claim period will help to expedite the forfeiture process so that agencies can commence any necessary works to address safety and health issues on the abandoned land. Ms. Nadia Samdin also highlighted situations where there are pressing concerns such as dengue, which might require a quicker response. In such cases, SLA will coordinate with the relevant agencies to consider the options available to address these concerns even before the forfeiture process is completed. The cases of abandoned land that we have encountered thus far involve mainly isolated strips of land like back or side lanes. These are typically incapable of independent redevelopment. On Mr. Yip Hon Wing's query on the type of land that qualifies for forfeiture under the bill, land is deemed to be abandoned and forfeited when no claims are established to it within the stipulated claim period. In other words, the lack of development of a piece of land does not in itself allow the state to forfeit the land. Also, for cases involving land owned by deceased individuals without beneficiaries, such as the Upper Thompson Road case cited by the member, the government becomes entitled to the land pursuant to the Interstate Succession Act 1967. The Public Trustee Office has separate existing procedures to dispose of the land that has so accrued to the government in accordance with the Civil Law Act 1909 and the Probate and Administration Act 1934. As for Mr. Louis Ng's and Ms. Nadia Samdin's query on the process for determining if land is abandoned, SLA will carry out checks with agencies such as the Immigration and Checkpoints Authority and the Inland Revenue Authority of Singapore to trace the whereabouts of the owners. SLA will only commence the forfeiture process if it appears that the land has been abandoned for 3 years or more and the owners cannot be traced from SLA's checks. To Ms. Nadia Samdin's question on the resumption notice, as mentioned in my speech earlier, a declaration will be made in the Government Gazette. This is similar to the current process under the State Lands Encroachments Act. In addition, as mentioned in my opening speech, SLA will also now publish the notice in the 4 official languages in major local newspapers, including the digital versions. This improves upon the current process, where SLA affixes the physical notice on the land, as greater publicity can be secured through publishing the notice in local media. This includes cases where the potential claimants are not physically in Singapore. Even after the land is forfeited, any person who can establish a claim to the satisfaction of the SLA within 6 years from the date of forfeiture can still be entitled to receive compensation for the value of the land. Taking this into consideration, potential claimants should have sufficient time within which they can claim compensation for their interest in the land. Mr. Yip Hon Wing asked how we can strike a balance between protecting state land from unauthorized use and facilitating community use of state land. As members would be well aware, Singapore has limited land resources. As custodian of our state land and properties, SLA is also continually looking for innovative ways in which our state land can be used to benefit the community. Where there are suitable vacant state lands which are not required for immediate development, SLA will also work with other agencies to put out these sites for public recreational activities. The current list of these community use sites can be found on SLA's website. The member has also mentioned NPARK's Community in Bloom initiative. We encourage members of the public to take advantage of these initiatives. Our concern with unauthorized cultivation and plantings on state land is that these can create potential health hazards such as mosquito breeding hotspots and impede the maintenance of state land. Unauthorized use of state land for activities can also affect public safety and potentially damage the land. Mr. Deputy Speaker, I believe I have addressed the salient issues raised by members relating to provisions within the scope of the bill. Separately, there were a number of comments relating to matters outside the ambit of this bill. First, I thank Ms. Nadia Samdin for her suggestion on the vesting of land to facilitate maintenance. Ms. Nadia Samdin may wish to file a separate parliamentary question on this matter. We will help provide her feedback to relevant agencies. Ms. Nadia Samdin also spoke about increasing protection for Singapore's marine spaces, in particular for the Southern Islands. While the question of marine spaces is not within the scope of this bill, I agree that this is an important issue which should be further studied, and we will convey her feedback to the relevant agencies. SLA will also consider her suggestions in its management of the Southern Islands. Generally, the enhanced enforcement framework under the bill will also better support SLA in protecting state land in the Southern Islands, from unauthorized use and damage. I thank the members who spoke in support of the bill, and I believe I've addressed their questions and suggestions. Mr. Deputy Speaker, sir, with that, on behalf of the Minister for Law, I beg to move.
The question is that the bill be now read a second time. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
State Lands Protection Bill.
Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 46 stand part of the bill. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. SPS Rahayu Mahzam.
Mr. Deputy Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
State Lands Protection Bill.
Leader.
Mr. Deputy Speaker, I beg to move that Parliament do now adjourn to a date to be fixed.
The question is that Parliament do now adjourn to a date to be fixed. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Order, order.